second panel, we have rather a perspective which is in relation to the remedies. As a lawyer, I am always favored to talk about remedies. We know that lawyers, we are pathologists by nature. So only when we have anomalies is that we are interested in. What strikes me a little bit, and as a way of linking the first panel to the second one, is that many issues that have been discussed in the first panel, they arise an issue on how the remedies will be applied. For instance, when you talk about reducing tariffs, it's easy. But when you talk about reducing subsidies, how you will enforce this kind of remedies. There are so many cases where panels at the WTO rendered decisions, and those decisions are not being enforced simply because they are not an appropriate remedy in the multilateral system. But this, of course, will be the subject of our panel number 3. On panel number 2, the importance of panel number 2 is because it is the remedies that are available and that we have to deal with. Of course, they do suffer the interference of political nature. For instance, in Brazil, when you see how these investigations are initiated and conducted, you have always a different perspective. For instance, from the Minister of Industry and Commerce, of course, always willing to impose or to follow the pains of the concerned sector of the industry. Maybe the Minister of Treasury has a different perspective because it will look on the inflationary effects of the measure, or even the Foreign Minister of Affairs because they would like not to undermine a specific relation to a certain country. Notwithstanding, these are very important tools available. And with these very preliminary remarks, I'd like to, first of all, I'm not going to introduce the speakers, first because they are very well known of you, second because we have the bios attached to the program. But I'd like to give the floor to Fernando de Magalhães Furlan, who is the director of the Brazilian Trade Remedies Department.
Good morning, everybody. Thank you, Sergio. I would like to thank Aluísio de Lima-Campos and ABCI Institute and Wilson Center and Professor Paulo Sotero for the initiative and the invitation. It's a pleasure to be here today. I'll start by presenting some figures and numbers on the Brazilian experience on trade remedies. Since 1988, when Brazilian government started to deal with trade remedies, there was, of course, before the structure we have today in Brazil, but we had some experience since that time. The figures show that about 50% of our measures imposed, 50% of the investigations initiated turned to final measures, and about 40% of the investigations initiated had no measures imposed. That is, that shows the balance between our position as a user of trade remedies and also our position as a country which is aim of other countries' trade remedies initiatives. We have right now 25 dumping ongoing investigations, and our total numbers are humble if compared with some other jurisdictions like the United States, for example. But we have, on the other hand, a very small team. We are about 30 investigators and 20 staff in the whole Brazilian trade remedies department. That is very, those are very humble numbers if compared with the, for instance, the American or the European structure. Of course, as all around the world, most of the trade remedies investigations in Brazil are related to anti-dumping, and a little portion of the investigations relate to subsidies and safeguards. Here we have already talked about this. The numbers are a little bit different from the previous slide, because actually these numbers relate to only to anti-dumping and not to all trade remedies investigations. But the numbers are very close to the previous slide. So we have right now 49 anti-dumping duties in force. One subsidy, one countervailing duty in force, and one safeguard in force. It's this safeguard case is, of course, a review. Here the numbers are a little bit different because as shown in the previous slide, we have 49 anti-dumping duties in force, and here appears 46 because we are considering the price undertakings as anti-dumping duties in force in the previous slide. We have 10 investigations under review, 4 price undertakings, 2 of them under review, and, as I told you, 1 safeguard in force and 1 countervailing measure in force. On the other hand, this slide shows how Brazil is being investigated in other jurisdictions. Our main partner in this issue is the United States, with 22 ongoing or in force investigations or duties applied, very closely followed by Argentina. And Argentina is getting closer each day more to the United States in the number of investigations and measures applied in relation to Brazil. Well, presented those figures and numbers, I would start my second part, the second part of my presentation, talking about Brazilian positions in international trade negotiations. We have been very active since the birth of WTO. The COM, which is the department we work, participates directly with Brazilian diplomats in WTO negotiations, specifically in the negotiating group on rules. But beyond that, we also have a lot of work to do with other negotiations, including Mercosur, European Union negotiations, and other Mercosur interregional agreements, for instance, with the South African Customs Union, with India, and etc. The COM also participates actively in other bilateral trade negotiations. For instance, with Argentina, which used to be our second trade partner, now is the third, because China replaced Argentina in the second place as the major Brazilian trade partner. With China, for instance, we were able to reach a very important trade agreement on textiles. Actually, this agreement Brazil reached with China on textiles was broader, even broader than the US and the European Union agreement with China on textiles. So that was a very successful agreement we reached with China. As I told you before, the Brazilian position in all those negotiations, including the WTO negotiations, is guided by the search of a balance, because Brazil is one of the world's most active country in trade remedies, and also Brazilian exports are being subject to investigations in many other foreign jurisdictions. So this position gives us maybe a balance of positions to act specifically in WTO negotiations, in rules negotiations, and we believe we participate in all informal groups. We are invited to participate in all informal groups. And we have been participating also in informal meetings hosted by the chairman of the negotiating group on rules. We heard from the last informal meetings of the negotiating group on rules that took place in Geneva last week. We heard some rumors that maybe the Doha Round would not include trade remedies or rules in its overall agreement. That, in our perception, would be a pity, because this is a very important and unique opportunity to clarify and improve all rules that are in the WTO agreements. So we understand that agriculture and market access are the most important issues, but that would be really a pity if rules will not be part of the final agreements of the Doha Round. So the objective of Brazil in all these negotiations, in all these trade negotiations, specifically and more specifically towards the negotiating group on rules, is the improvement of the rules and the clarification of the rules. Also, very important is the reduction of the level of discretion of the investigating authorities. Brazil has been acting very proactively in this concern. As I will show you afterwards, Brazil has presented a lot of papers individually and with other countries in the negotiating group on rules, including a paper, a very important paper, with the United States. Which are the main issues in the negotiating group on rules in the Brazilian perception? One of them is the prohibition of the use of zeroing. All of you probably know that we have a recent decision from the appellate body in the WTO establishing that zeroing would be prohibited for original investigations of anti-dumping and also for reviews. I had the opportunity to be yesterday with the Assistant Secretary for anti-dumping in the for Imports Administration, thank you, in the Department of Commerce, and we had the opportunity to discuss briefly how the United States intends to implement that appellate body decision. One of the second main issue in the Brazilian perception well, here we have a problem with the slides, but the second issue would be the lesser duty rule. Brazil has been very active in defending this position in WTO. We apply this rule in all cases we have before us in Brazil, and we think this should be a practice that all countries all around the world should follow. We understand that, and we're trying to sell that position to other members of WTO because, in our perception, when you impose a duty, that duty should be necessary only to impair or nullify the unfair practice, nothing beyond that. So this is what we are defending in WTO negotiations. We have, in our papers, presented some methodologies for calculating this non-injurious price. Some of them are the constructed price of domestic industry, and then we establish an average cost and a profit for the domestic industry. The other one would be the price of the domestic industry, the price that domestic industry is using at the moment. That will be also a third methodology that will be the domestic industry price, but in a period before the dumping in the country. That will be the price of domestic industry before the prices were affected by the dumped imports. In our perception, that will be the most appropriate methodology to be used. Of course, all these methodologies are not straight. We could use each one of them. There is no hierarchy between them, among them, and also a lot of flexibility. The third issue, important issue in our perception, is the sunset review. Brazil supports this paper presented by Japan in general terms. We believe that the last paper presented by Japan was an improvement from the first one. In the first paper, Japan wanted to establish that sunset reviews would be prohibited. In the last paper, Japan flexibilized its position, and now Brazil is ready to give more support to this paper. And this last paper brings more clarification in the criteria used to take advantage of the sunset reviews. We support that the sunset reviews would be made only if there is a request by an interested party. So there would be no ex officio initiation of sunset reviews. Also, we should have more criteria, more clarification in the criteria for the likelihood test of dumping and injury. And third, we believe that sunset reviews, as well as the original investigations, should have more clarification in the standing rules. Some other issues that Brazil understands important, but not so important as the third I pointed out before, are the definition of product under consideration. It is very important for an anti-dumping investigation that you have clear what is the product that you are investigating. For you to define what a like product is, it is important that you have in mind exactly what is your the product that you are investigating. Second, we believe that the reviews under Article 11.2 need more explicit rules and proceedings. Also important, the definition of domestic industry. The WTO current rules talk about a major proportion of the domestic industry, what that major proportion would be. So we believe that the new rules should establish what a major proportion is. If it is the major proportion, 50% or more of the domestic industry. So we believe that this needs more clarification. As I told you before, we also defend more transparency in the proceedings of anti-dumping investigations. And we presented an important paper with the United States on the identification of parties. We believe that investigating authorities should play an active role in finding which the petitioners are, not only which the petitioners are, but what is the domestic industry. So we should rely not only on the information presented by the petitioners, but the investigating authorities should actively search for information on other enterprises which are in the domestic industry, as well as all exporters involved and all importers involved. So we believe that investigating authorities should search for information wherever necessary to find the best information. In relation to countervailing measures, Brazil presented some papers in the negotiating group on rules in the WTO. The most important are those which involve the definition of interested parties in countervailing measures investigations. Also, on provisional measures, all this relates to the fact that the anti-dumping agreement is more clear or more detailed than the subsidies agreement on all these aspects. So we believe that the subsidies agreement, subsidies and countervailing measures agreements should be clarified at least as much as the anti-dumping agreement is. And on these three issues, more importantly, as I was saying, the provisional measures is a very important issue to be clarified in the subsidies agreement, because we should know better beforehand which are going to be the means of the payment of the countervailing duties and the period of application of these provisional measures. Finally, we need more rules for the refund reviews in the countervailing measures. All these issues relate, as I said, in taking into consideration the anti-dumping agreement. Well, that is my part of the presentation. I am at your disposal for any questions afterwards. Thank you.
Thank you very much, Fernando, and thank you for keeping the time strictly assigned to me by Aluísio. And now we move to Cláudia Marques from the law firm Verani Advogados. And with her, we'll complete the Brazilian perspective, I guess, leaving to you to focus on the U.S. perspective of the question.
Okay. Well, first I'd like to congratulate ABCI and the Brazilian Institute at the Woodrow Wilson Center for putting together this symposium. And I'm very happy to be here today, and I hope I can add some valuable contribution to this excellent discussion. Director Furlan has already given us an introduction on the figures and how the Brazilian government has been conducting anti-dumping and countervailing duty investigations.
Sorry, Claudia.
No, no problem. Just to break
It's
it
not
up.
enough to have ice outside.
Okay, so I'll just go ahead. I've been practicing trade law for the last couple of years, and I'd like to share with you my experience in the practice of especially anti-dumping investigations in Brazil and the developments I've seen on the authorities' work during this period. I will only speak about my anti-dumping practice because Brazil has not been very active on the CVD area. Not recently, but since 1988, there were only 15 CVD investigations initiated by the Brazilian authority. Out of those, 12 were prior to 1995. So Brazil's been very active on the anti-dumping investigation. My numbers differ a little bit from what Director Furlan has provided us because I've used the last DCOM's annual report that was available, which reports the numbers until 2005. The 2006, I think it's not available yet. So on the dumping area, we've seen during the year of 2006, well, Brazil has always been very active on the anti-dumping area, but particularly in the year of 2006, there were 11 new anti-dumping investigations initiated and 7 new sunset reviews. Out of these, like 100% of the new investigations were against the imports from China, and 4 of the sunset reviews were initiated involving China as well. So before that, from 1988 to 2005, there were like 225 anti-dumping procedures initiated. Out of those, 32 were against China, being 21 investigations and 11 reviews. So this is interesting because if you compare to the United States, for example, which I was told initiated 3 anti-dumping investigations in the last year, we noticed that Brazil has been very active and has been increasing its participation in this field. So considering this increase of Brazil's participation in anti-dumping investigations, and especially from China, what I have prepared for today is an overview on the treatment of China in anti-dumping procedures in Brazil. So especially on the most interesting part of this is that how Brazil treats non-market economy countries in anti-dumping investigations. So this is mainly interesting because the anti-dumping agreement does not provide for any treatment of non-market economies. So, but the WTO has recognized that a rigid comparison of prices is neither possible or nor appropriate when the government of the country in question has a complete or substantially complete monopoly of its trade and or where all domestic prices and production costs are fixed by the state. So in these cases, importing countries' investigation authorities have exercised a wide discretionary power on calculating especially normal value for products exported from non-market economy countries. So in Brazil, just to give you an overview, the procedures regarding the imposition of anti-dumping measures are regulated by Decree 1602, and this decree has a specific provision on the determination of normal value in cases involving non-market economies, which is Article 7 of this decree. It basically determines that normal value should be calculated either of these three ways: on the actual price or constructed price of the like product in a third market economy country, the export price of the like product of a third market economy country to other countries excluding Brazil, and just whenever those two options are not possible, on what they call any other reasonable price, which includes the price paid or to be paid for the like product in the Brazilian market. There are some other provisions in Article 7 clarifying this a little bit. So the selection of a third country, how do you select that? So paragraph 1 of Article 7 informs that any reliable information will be considered by the investigating authority when selecting the adequate third country. Paragraph 2 clarifies that a little bit, saying that whenever it's possible, the authority shall use a market economy country that is the object of the same investigation. This is what has happened in some cases where the investigating authority has used the United States or Argentina in some investigations involving China and those other countries as well. Paragraph 3 of the same article rules that interested parties shall be notified promptly after the initiation of the investigation on what this third country would be. So, with this information, we have clear that from the Brazilian law perspective, we don't have any rule on how on the definition of, I'm sorry about that. Brazilian law does not provide any definition or list of countries considered to be no-market economies. So in the Brazilian law, there's nothing about that. But if you can find a list at the electronic form for pre-analysis of anti-dumping requests, which is available at the DCOM's website, and it lists some countries which would be considered to be non-market economies, which is this list you can see in here from the text, the language of footnote 19 from this electronic form, which includes China, and that determines that the normal value may be determined based on one of the designated alternatives, which are the alternatives from Article 7. So this, from here, we know that China, the Article 7 rule applies to China. So we also have another provision in Brazilian law, which is a circular from the Secretary of International Trade, which is number 59 from 2001, and it also complemented and clarified Article 7 of Decree 1602, and especially added this Article 3.1.2, which reads that during the investigation, the farm producer and its relevant government may present elements of evidence aiming at the reevaluation of the predominantly non-market economy. So Circular CSX also gives some orientation on how to evaluate the condition of a market economy country. And you have to follow this these items, for example, on checking whether it's a market economy country. For example, the degree of governmental control over companies or over their means of production, the degree to which salaries are determined freely in negotiations between employees and employers, the level of government interference in foreign exchange transactions, and several other items. But it's important to mention that market economy treatment will only be granted when sufficient evidence is provided that the market economy situation exists. So that's why you have to take into consideration these items in here in evaluating that. Also, Circular SSX, just an additional information, innovated by providing a list of countries which they consider, the authority considers to be economies in transition, such as Bulgaria, Slovenia, and the Czech Republic. These countries were raised to economies in transition without any evaluation or public debate on the matter. And according to DICOM, these countries have implemented important measures to remove state monopoly, governmental control, and interference in domestic prices. In practice, what does this mean? It means that the rise of those countries to be considered economies in transition is that Articles 5 and 6 of the Decree 1602 will be used to establish normal value, which is that normally practiced in the domestic market of a country with an economy in transition. So this is a bit of an introduction. And then what I've done was that I conducted a review of all anti-dumping investigations Brazil has initiated and concluded against China until 2006. I've not considered for this purpose the cases that were initiated in 2006, which are the 11 relevant cases. So, in practice, DICOM has normally determined normal value based on the price practiced by a third country with market economy in its domestic market, which is choice number 1 from Article 7 of Decree 1602. The choice of adequate country has normally been the U.S., because it was also another country under investigation, and Argentina as well. So what we see is that there is no legal criterion for selection of the adequate third country in anti-dumping investigations. So if we take the 11 investigations that were initiated in 2006, we see no consistency at all in the determination of normal value for China. Those cases, I have them all listed, but I wouldn't not put in the presentation. If some of you want to get some more information on that, I can provide you. But we've seen that DICOM has used the 3 options from Article 7 in calculating the normal value for China. It has used the export price of a third market economy country to other countries excluding Brazil in 4 cases, the price or the constructed price of the like product in a third market economy country in its domestic industry in 4 cases, and it has actually constructed the normal value for China based on the domestic industry's cost of production in other cases. We've seen that the third option from Article 7 was that DICOM can determine the normal value on any other reliable, available information. But the construction of the normal value based on the domestic industry's cost of production sounds a little weird to me. So in reviews, I was speaking about anti-dumping investigations, but in reviews, DICOM has normally determined the normal value on the price practiced by this third country with market economy for its sales to other countries. The choice of adequate country has been many: Germany, Denmark, Korea, Taiwan, the United States, and etc. We've seen, we all know that China acceded to the WTO in December 2001, and that China's protocol of accession gives WTO importing members an alternative for determining normal value when there are non-market factors influencing the economy and distorting prices in China. The burden of proof, however, lies on the foreign producer manufacturer in proving that, on following, demonstrating that market economy conditions prevail in that sector or for that specific industry. So, what else? Okay. It's an important information for some of you who don't know that. Brazil has signed a memorandum of understanding with China in November 2004 for cooperation in terms of trade and investment. And a particular provision of this memorandum determines that Brazil would recognize the market economy status for China. So this was one step forward because Brazil did not recognize China as a market economy simply because of its accession to the WTO. And Brazil has continued treating China as a non-market economy country. And even with the signing of this memorandum in 2004, Brazil has not implemented, it politically recognized China as a market economy country, but it has never brought this condition or any associated criteria for doing so into the Brazilian legal system so far. So since this memorandum was signed in 2004, Brazil had not opened any new investigation for a year and a half. The other, probably because Brazil was waiting for China's move on some of China's obligations under this memorandum, which would involve some phytosanitary certifications, a joint cooperation for aircraft manufacture, and etc. But after a year and a half, as nothing changed, Brazil then in 2006 opened this 11 new anti-dumping investigations against China. Just an information to, as going forward to the conclusion, the Chinese protocol of accession to the WTO was brought into the Brazilian legal system through Decree 5544 from 2005. And for that reason, Brazil may choose to use either Chinese prices or a methodology not based on a strict comparison with domestic prices or costs in China in determining normal value, which is combined, as we've seen, with Circular 59 and Article 7 of Decree 1602. Let me see if I have something interesting for this short time. Okay, so just to conclude now, although there was a signed memorandum between Brazil and China on the treatment of China as a market economy, the current situation is that Brazil has not been considering China as a market economy. It's an anti-dumping investigation at all, and it has actually initiated 11 new investigations and reviews as well against the imports of China. And until Brazil decides to add this decision to treat China as a market economy into its legal system, it will, I suspect, continue treating China as a non-market economy in anti-dumping procedures. And the exception for that, for the Chinese, especially manufacturer, foreign producer, is that the exception operates when the foreign producer can demonstrate satisfactorily, according to the rules of Circular 59, and combined with Article 7 of Decree 1602, that for that specific industry or segment of the economy, a market economy operates. So, and this is, as I said, fully supported by Circular CSX 59 from 2001 and Article 15 of Chinese Protocol of Accession to the WTO. So I'm open to any questions you may have. I know I've provided you a lot of information on the Brazilian legal system. But I think it's a topic that's very actual, and it's been interesting to study how Brazil has been treating China on these anti-dumping investigations. So thank you very much.
Thank you, Claudia. It was very interesting aspects you brought, including this fact that Brazil signed an agreement that giving this status to China was very much criticized in Brazil and abroad at that time. First, because being or no, a economy of market is a de facto situation, and it's not by decree that you recognize. But the fact will be, of course, to reverse the burden of proof, which eventually will facilitate the defense of Chinese companies under investigation. Now we move to the U.S. perspective. I think I will begin with keep the same strategy. Then you talk first about trade policies, and then Terence will comment even your speech.
Thank you for that introduction, and Aluísio, thank you for inviting me again this year. I was actually a little. It's becoming a tradition. I was a bit surprised because last year I had the audacity to suggest that Brazil could be doing more to advance the Doha talks, but Aluísio invited me back nonetheless. And Aluísio called me and said, "Dan, I want you to do two things. I want you to talk about trade remedies, and I want you to be upbeat, optimistic about Doha's chances." So I'm happy to tell you, Aluísio, that I am going to oblige you on half of that. Again, my name is Dan Eikitson. I'm the Associate Director of the Center for Trade Policy Studies at the Cato Institute, and we've done a lot of research on trade remedies, in particular anti-dumping. And if you're interested in seeing any of our stuff, you can go to freetrade.org. We have a lot of papers that we've done on anti-dumping. Last year I spoke about, fairly technically, about some of the proposals in the rules group, prospects that some of them would come to fruition. I'm not going to focus on the details of those negotiations anymore, primarily because I really think that it's a long shot that anything is going to come of the Doha Round in the next few years. And despite the fact that the talks were relaunched, and that champagne flutes might be clinking in Brasilia and Brussels and Geneva, not so much Washington, I'd say. I just don't think it's going to happen. Agriculture, of course, has been the focus of the holdup for several years now, and rightly so. I don't see Brazil and India and the countries that are represented by Brazil and India in the G20 getting excited about a U.S. proposal to reduce agricultural support from, say, $20 billion to $17 billion. It's not significant enough. But to a certain extent, it's easy to point to the United States and blame them. It's easy to point to Europe, blame them for their high tariffs. But I really don't think that there is a whole lot of genuine interest in a new agreement that binds countries to new rules. I think countries recognize that it's important to liberalize, that it's good for their economies, but politicians want to do this on their own timetables, according to their own schedules, and they want to be able to have recourse to backtracking. Yesterday and again next week in the House Ways and Means Committee here, we're having hearings on the impact of China on the U.S. economy. Well, if the United States is concerned about China, if Europe is concerned about China and is bringing dumping cases and keeping its clothing out, think about the developing countries who actually compete with China. I think the developing countries have right to be a little bit more concerned about the displacement than the United States and Europe do. So I think that is at the heart of why we're not necessarily going to have an agreement. That doesn't mean that the United States is not going to try to extend trade promotion authority, which expires on June 30th. I think there is an effort to do that, and part of the impetus for that, I think, is that there's an interest in deflecting blame. It's pretty easy to point the finger at the United States as the main reason the Doha Round did not come to fruition. If Trade Promotion Authority is allowed to expire. So I think we might see something happen on that end. And I shouldn't say that Doha is dead or that it's going to die, but that it's it's in a cryogenic state, and it can be reanimated at a future date, but it's just not going to happen in the near future. But I also think that the tales of what is going to happen if Doha collapses have been overstated. The world economy is growing very well, very handsomely. Trade flows are increasing at twice the rate as world economic growth. We're still realizing the benefits of the Uruguay Round implementations. China and India and Brazil and other large developing countries are coming online now. So I seem to think that international trade is going to continue to be a tremendous source of economic growth. And eventually we will get back to negotiating agreements. Countries will likely in the interim engage in their own unilateral reforms when they recognize it's in their interest to do so. If it's in your interest to make your country business friendly, to open yourself up to investment and services or whatever other industry, you're going to do that. And you don't need an agreement to do that. So I'm looking for that to happen. Let me talk a little bit about trade remedies, which is why I was invited to speak here. I'm going to focus on anti-dumping because in the United States that is the primary trade remedy. We haven't had a safeguard initiation in 5 or 6 years. There have been just a few CVD cases, although a prominent one recently, which I will touch upon. But there's good news on the trade remedy front in the United States. In the 11-year period between 1995 and 2005, we had an average of 33 anti-dumping initiations a year. By 2004, we only had 26 initiations. 2005, there were 12 initiations. In the most recent 12 months, there have been only 4 initiations in the United States. And the same trends are evident worldwide. Not so much in Brazil, as we just saw, but overall, anti-dumping use has gone down. And I think that there's some important factors behind that, some that are structural and permanent, some that might be considered more transitory. The most important one is that the U.S. economy, the world economy have been growing consistently, handsomely for a while. And it's hard to demonstrate injury when the economy is expanding. I think injury, as you know, is, for the legal proceedings, is based on the conditions of a particular industry. But there is a very strong correlation between overall economic conditions and initiations over time, anti-dumping initiations. One of the major factors, which is, I guess, within that broader factor, is the health of the steel industry in the United States and worldwide. In the United States, the steel industry has accounted for the preponderance of anti-dumping initiations over the past couple of decades. In fact, 208 out of 366 initiations over the past 11 years have been filed by the steel industry. That's 58% of the caseload. Since 2003, which is the year that the steel industry really started its major turnaround, there have been only 10 cases filed by the steel industry out of 77, which is 13%. And in 5 of those cases, the ITC found that there was no injury. So I think that explains a lot of the diminution of anti-dumping initiations. World demand outside of the United States is growing fairly strongly as well. In the past, whereas it may have been the case that business planners in developing countries or other countries looked exclusively to the U.S. market as their future, they don't do so quite as much anymore. I think that trying to compete in the United States on the basis of price is less significant, less prevalent than trying to get in developed customer bases in China, in India, and in other markets that are growing. It has sort of supplanted the other model. That explains the decline in anti-dumping as well. And the fact that we do have these emerging markets throughout the world, that transportation costs are a lot higher, I think is causing more of a regional focus. Companies are producing regionally for regional consumption to a certain extent. And as globalization has progressed, foreign direct investment has flourished, supply chains have gone international, and now there's a concern if you're a company, you might not want to bring a case because the chances that you will ensnare somebody in your supply chain or another entity that you are related to in some other way in the case is higher now. So I think that there's a greater downside to bringing cases. This was evident in a pretty big case launched a couple of years ago here on bedroom furniture from China. It took the Department of Commerce quite a while to get the case initiated because there wasn't sufficient domestic support. One of the reasons was a lot of the domestic producers were sourcing in China. And they didn't want to bring cases against entities in their supply chain. So I think that is becoming a little bit more prevalent. And in fact, in the Chinese case, the Byrd Amendment, I think, had to be incited to encourage companies to actually support the case. The Byrd Amendment, which you all are probably familiar with, which is a law that was passed a few years back, which diverts anti-dumping and countervailing duties collected by the Customs Service to the petitioning industries. That law will no longer operate as of September or October of this year. Despite the fact that dumping is on the decline, I think that there are some worrisome trends that we need to be concerned about in the United States. One of which is the Congress is very strongly in favor of the status quo on anti-dumping, if not making the law more user-friendly. There's broad bipartisan support for anti-dumping, and that has been the case for a long time, and it's been a very difficult trend to reverse. Last year, there was a bill introduced by Phil English, who's a Republican from New York, called I think the Trade Law Reform Act of 2006. That law would make it easier to find injury. You wouldn't have to attribute injury to imports, which is now the way the law is, at least the way the court has interpreted the law to apply. I think that law will be that bill will be reintroduced this Congress. Other bills like that will be reintroduced. If you read letters from the Congress to the President on trade issues, support for anti-dumping, the anti-dumping status quo is always written into the letters, even if the subject has nothing to do with anti-dumping. So I think we're going to have a hard time with Congress there. Another thing that happened over the past couple of years, which kind of flew under the radar, are the settlements of cases. We had a real big case a couple of years ago on shrimp. Brazilian exporters are involved in that case, as are exporters from 5 other countries. What happened is, after the investigation, rates were set for these hundreds of exporters from these 6 different countries. Many of the rates were manageable in the sense that exporters continued to export to the United States. Consumers were willing to absorb the slightly higher prices. Single-digit dumping rates prevailed for many of these deposit rates prevailed for many of the companies. Petitioners decided to initiate or request administrative reviews, which is what happens here in the United States. And when those review requests were made, the petitioners went to the various exporters and said, look, we recognize that you might be happy with the rates that you're currently paying, 6-8%. You don't want any uncertainty to enter the equation. We will rescind our request for reviews if you pay us X% of the sales value in the United States. Hundreds of companies accepted these deals. I think that's foreboding. I think that might not be illegal. Both parties came out happy, but it's extortion. And it's happened in the Chinese furniture case as well. It may have happened in other cases. But petitioners, I think, are looking for a way to replace the Byrd Amendment. The Byrd Amendment's coming off the books. How do we get our domestic companies to support cases, to bring cases? Well, this is one way to do it. If you can come up with an equation that shows this sort of the capacity for the dumping law to be a cash cow, we might see anti-dumping activity increase again. Now, let me speak to a couple of other issues that are going on. Earlier, somebody referred to the zeroing decisions from the appellate body. I'm very concerned about that. I'm happy to see that the appellate body has ruled against zeroing. In the European case, they ruled against zeroing on an average-to-average basis in investigations. The appellate body came back and said, well, you can't zero in a review either. In the more recent decision that came out from the appellate body in early January, the zeroing on a transaction-to-transaction basis in investigations and reviews was also impugned. The Congress is a little bit upset about what's going on. There are assertions that the appellate body is overstepping its bounds and reading in obligations into the agreements that the United States believes don't exist. Terry might be able to address that a little bit when he speaks. But my concern is that the United States decides not to comply with any of these rulings. A few years ago, Max Baucus, who at the time, I believe he was chairman of Senate Finance at the time, introduced legislation calling for a panel of retired judges to review all adverse WTO decisions and make a recommendation as to whether or not the United States should comply. That bill has been reintroduced by Phil English, I think. It was reintroduced, I think it was in a recent English bill. So there is some contentiousness in the United States. There is some concern that, if the Doha Round is not ongoing and we have these disputes and they're unresolved, what's going to happen? To me, what will make Congress do the right thing in the long run is the fact that if we want China to comply with its obligations, if we want to see them comply with the most recent complaint we brought on subsidies, we're going to have to do the same thing. And to me, that's the greatest threat to the trading system, is if we start to disregard the rulings from the WTO system. It has served us well, and we need to show it respect, even if we disagree with the outcomes. The fact is that complainants win. I looked at some research a few years ago. I'm looking to update it now, but as of a few years ago, complainants in WTO cases won 88% of the time. And when the United States was a complainant, it won about 88% of the time. And when it was a defendant, it lost about that same percentage. There have been a lot of cases brought into the WTO dispute settlement system concerning anti-dumping recently. So the United States has incurred quite a few losses there. So there is this perception that there is an anti-American bias in the WTO, and I don't think that that's true. The only other real major development in the United States, in my view, on trade remedies or on dumping is the recent case involving paper from China. It's been 15 years since the Department of Commerce initiated an anti-subsidy case or a countervailing duty case against China. There's been a lot of interest in Congress to subject China to the CVD law. Quite frankly, I don't think there's anything wrong with that. I think China should be subject to the CVD law, and I also think, one of the positive outcomes from subjecting China to the CVD law will be that it does improve the case for graduating China from non-market economy status to market economy status for purposes of dumping cases. But we'll see how that all pans out. Other than that, dumping trade remedies have been fairly quiet in the United States. I'll take my seat and be glad to answer any questions later. Thank you.
And I thank you, Dan, for keeping the time. And also, may I remark that there is always nobody accepts when it's an unfavorable decision made. Yeah. So the problem is really to enforce it, either you like or not. So now we move to Terence Stewart.
Thank you very much. I join my other speakers in congratulating the Institute and the other sponsors for putting this program on. I'm going to focus my comments on what has been happening in the last year or so in U.S. trade remedies, and this will be fairly technical. Before I start that, let me just make one comment about the zeroing issue. I think the issue from the U.S. perspective, certainly from the congressional perspective, is that when the dispute settlement system was put in place, it was a system that was intended to be of limited jurisdiction. Panels in the appellate body, by agreement, are not permitted to create rights or obligations that aren't contained within the agreement. Where the difficulty with that obligation is that it can't be enforced, because if the appellate body renders a decision that you believe is in fact creating an obligation on you that you did not agree to, in a negative consensus system, you basically have few, if any, options other than to pursue negotiations. Now, you can go back to the civil aircraft dispute between Brazil and Canada, and I've had the opportunity to deal with many Canadian and Brazilian officials in Geneva over the years, and they are both working within the negotiations to try to achieve correction of what they each view as erroneous decisions, obviously in opposite directions. And the same thing is true in zeroing in a number of other issues. I guess I would say we'll see what happens on that issue in the United States. I have 8 categories of developments here in the United States. The most important category deals with non-market economies. First, last year, there was a reconfirmation in the United States in a challenge involving line paper that at the present time, China will continue to be treated as a non-market economy under the U.S. system. That was a big issue for China at the time, obviously a big issue for domestic industries who wanted to have non-market economy methodology apply. So change one under NME. Second, during the course of the last year, Commerce announced a number of changes in their NME methodology. These were responsive to concerns from really parties on all sides as to whether or not the methodology was reasonably capturing a fair proxy for normal value. You heard in the earlier presentation how Brazil does it. The first option that Brazil uses used to be an option the U.S. pursued. We don't do that anymore. We now basically are limited to the second option. Typically, the surrogate country is India, although not always in the case of China. And one question that has come up repeatedly is, what do you do if some of the inputs that are bought by a Chinese producer are from a market economy? Do you use those to value the inputs that come from non-market economies, particularly those that come from China itself? That methodology was modified somewhat during the course of this past year so that it will be a blended rate unless more than a third of the inputs have come from market economy suppliers. Labor rates, there have been some litigation involving what kind of a labor rate should be used. There has been a revision in that, and that number actually reduces the labor rate that will be used on Chinese cases, at least at the present time. Fourth, there is a consideration about whether or not the treatment of duty drawback claims in NME context should be modified to reflect a proportionality, meaning that rather than assuming that there's duty drawback for all inputs that go into products that are exported, whether it will look at the totality of the purchases of the inputs and use a percentage in that regard. So those are all changes in NME methodology that affect the dumping calculus. The vast majority of cases in the last number of years in the United States that have been brought have been cases on NME country products, and so more attention has been there in terms of commerce practice procedures and changes that have been made. The CVD law application NMEs, important development. The initiation of the case on the coated free sheet paper from China is interesting, potentially very important. Commerce has not made a decision yet that they will change their policy of not countervailing subsidies in non-market economies, but the initiation of a case is certainly in the right direction. Second category of issues I wanted to discuss is other anti-dumping methodology. Really the only major issue I can think of there is the zeroing decisions and what happens, and you've heard a variety of views of what that may be. On the third category, other countervailing duty methodology, there is a current notice out looking at whether Commerce should have a different approach and change circumstance reviews in CVD cases where there has been a change in the identity of the party who is subject to review or investigation. And this has to do with whether or not the the underlying principles in the countervailing duty law are different enough from dumping that one should have different policy objectives in looking at what rates get applied if Company A gets bought by Company B and is no longer in existence in terms of the rate that would be applied. There were two important court decisions in 2006 at the U.S. Court of Appeals for the Federal Circuit that deal with the International Trade Commission's practice. And I would say that if you're looking at it from a petitioner's point of view, well, a petitioner or respondent's point of view, one was kind of a return to the status quo in terms of the proper role of the courts in reviewing. It's a case called Nippon Steel. The chief judge of the Court of International Trade had a review of a original investigation on 10 mil products from Japan, where she kept reevaluating the evidence and finding the evidence in support of the Commission's determination to be wanting. There were several reversals out of the Court of Appeals with a final reversal that basically said you got the standard wrong. The standard is a deferential one. The agency is the fact finder and obviously has the opportunity to weigh credibility, et cetera, et cetera. Second case, and that works to the advantage of whoever wins at the ITC. I mean, if you're a respondent and you've won the case at the ITC, you're happy with that decision. If you're a petitioner and you've won, you're happy with that decision. Obviously, if you're on the flip side, where you're the one who lost and you would like to take an appeal, the standard of review is what it is, and is not necessarily a happy face issue for the losing party. The second decision out of the Court of Appeals is a case called Brass Aluminum Smelter, and it is a case unclear as to how broad its application, which the Court of Appeals suggests or mandates that the Commission in certain cases look at whether or not the domestic industry will be a beneficiary if an order is put in place if there are non-covered countries who are underselling the domestic industry at the same time, i.e., can you have material injury caused by imports if the removal of those imports will simply result in a substitution of other imports that are not covered by the pending cases? So those two decisions are important. What will happen with Brax is unclear. Case is back at the CIT with a remand determination due out in late March. Some very important developments in the last couple of years have had to do with enforcement of orders and the collection of the amount that's due. Obviously, in any system of duty collection, if at the end of the day you don't collect the duty that's owed, one has to wonder what the game has been about and how the process is supposed to work. There have been two separate issues that have had developments in the last year. One deals with the situation where an order is in place, cash deposits are being posted, but there is an inadequate continuous entry bond accompanying the imports to cover the potential liability if there is a significant increase in liability at the end of an administrative review. Customs has made some announcements as to what they will do in that regard. To date, it's been limited to a subset of cases. In fact, only one case, I believe, to date has faced those new rules, but it's to try to provide greater protection to the U.S. revenue, which Customs is mandated to protect. The other it was a change in law of a temporary nature, which says that in new shipper reviews, which have been have occurred in quite a few cases, but a lot in cases involving non-market economy goods, particularly aquaculture or agricultural cases from those countries, where under U.S. law and under international agreements, you're supposed to provide the opportunity for goods to come in under bond during the time that a new shipper is being reviewed. U.S. has had enough difficulties with whether these are bona fide reviews that they've gone back to a cash-only requirement for a period extending out to June 2009. So that's the enforcement set of issues. They are important practically in a limited number of cases, but if you're involved in those cases that are important to you, on whichever side you happen to be. Then there have been a lot of procedural issue changes at the Commerce Department. There is currently a proposed change in the APO system, which is really designed to catch the system up to some of the realities of specialized situations. If you do a new shipper review, Commerce has now done enough of those where there's a certain portion of them which are not bona fide new shipper reviews and where Commerce will ultimately end up rejecting. At the present time, you don't get an administrative protective order before the new shipper review has been conducted, and so the proposal is to permit access at the time a new shipper review is requested, so that if a party believes that it's not bona fide, they can try to raise that to prevent the utilization of resources. Same thing is true in the U.S. in what are called scope requests, where Commerce can make a decision on the basis of the scope request itself if it believes it is self-explanatory and answers all of the questions that they would have. They're going to provide opportunity for other parties to gain access to that before a scope review is actually commenced. Commerce is slowly moving into the 21st century by doing a pilot program on electronic filings. At Commerce, obviously a lot more difficult because of the huge amount of protective order information and how you deal with that. But we're involved with a case that's been in pilot program for I think a little over a year. And at the same time as technology evolves, some of the restraints that Commerce has had have been lifted. This goes particularly with the sampling. Obviously, with computer power being what it is, the justification for deciding to sample in most cases no longer exists, and so it's harder to get Commerce to agree to do that. Seventh, in October, in response to requests from a number of parties flowing in part out of the Katrina rebuild in the Southwest, a Federal Register notice announcing the ability to seek a waiver of dumping or countervailing duties where the goods are being brought in to facilitate emergency relief work was put on. Whether this is a footnote or something significant in a particular order, time will tell. My guess is it's a footnote. Other issues that may be worth noting first would be the reconfirmation of the ability of Commerce, or for that matter the ITC, to reopen a closed case where fraud has been demonstrated. There was a case on large newspaper presses where court litigation uncovered what was believed to be fraud in the case of a Japanese producer in an in a Commerce questionnaire response. The case was reopened by Commerce, was upheld on that basis at the CIT. Settlements, I would look at them from a different perspective. Over the course of the law, where you have complex cases, the parties, sometimes including the governments, seek to pursue settlements. The big settlements that occurred in the last 2 years were not the ones that Dan mentioned, but rather the softwood lumber settlement and the Mexican cement settlement, which were fairly traditional settlements, meaning you had complex sets of layers of litigation where parties got together and agreed on a wrap-up of all litigation and the underlying disputes. With that, I will stop.
Congratulations on time. Did I perform? So thank you very much, and let's move to questions. Open to the floor.
I'll take the prerogative if you don't mind. It became clear from all the comments that China seems to be a problem, not only exclusively in Brazil, but everywhere. As a matter of fact, it doesn't matter whether you talk to someone from the industry, you're going to hear something about China, whether they're either importing or exporting, or they have a problem. You talk to the authority in the U.S., talk to the authority in Brazil, there is a problem. You talk to the lawyer in Brazil, it depends on which way he's working, which side he's working, and then there's going to be a problem. So I think China is by all means a big general problem for trade remedies, be it from the regulatory side, be it from the application of the law side by lawyers and practitioners. So my question to you all is, how do you view this problem? What's the way you see this problem from being solved from your own perspective, be it from being an importer, being a competitor, being an authority? How do you see this going?
May I add to your question one remark that, of course, the fact that China is a non-market economy gives you all this difficulty to implement, and but then would lead to another question: why in Brazil and in the U.S. safeguards are not being used? I mean, if you have a technical problem in implementing the countervailing, the anti-dumping system, why do not use the safeguard, or at least more than you are using? In Brazil, just one case I noticed, and in the U.S., no.
Well, let me start on the last part of the question. In the United States, we have a section that implements the transitional safeguard that is China-specific, and there had been efforts to utilize that where needed. I mean, one needs to understand that while China may quote unquote be the problem, they're obviously an important trading partner for both of our nations, and relatively little trade is actually affected by the trade remedy cases that are brought. What I tell my friends in China is, it's not surprising that there are so many cases. It's surprising there are so few, because the pricing is highly disrupted. But in the United States, the reality is that the safeguard mechanism that was designed to deal with China's transition to much more of a market economy has to date not been allowed to work. There have been 6 or 7 cases filed. Most of those were won at the ITC. None of them passed muster at a political level at the administration, and you need to understand that China has worked very hard to see that that would be the case.
This is the situation in Brazil too.
I would agree with Terry. I mean, the law exists. Petitioners have brought these 421 cases, and at the end of the day, the president has said it's not in the national economic interest of the United States to impose these prescribed tariffs or quotas. I wouldn't look at China really exclusively as a problem. It's also an opportunity. China has come a long way implementing the obligations it agreed to when it acceded to the WTO. Still has a long way to go. I think the world granted China a honeymoon period. I think that honeymoon period is over. Only the United States has brought cases against China. I think to a certain extent, nobody wanted to be the first to get litigious with them. But the United States brought a case on chips a few years ago. That was resolved in negotiations. The auto parts case, which Canada and the EU EC joined, and recently the subsidies case. I think it's legitimate that we hold China to its obligations. But at the same time, we have to recognize, yes, we have a huge trade deficit with China, but our exports grew last year at 32%. China represents a huge market. They're not closed the way perhaps Japan was, a couple decades ago when it was the bête noire of the United States. So I think that if we address the problems as they arise, I speak as a person who's not involved in business. I work in an office here. I don't do importing and exporting. I'm not on the ground, so I don't appreciate maybe the acuteness of the problem that some people would characterize it as, and nor do I really fully appreciate the benefits that exist. But it's a two-way street. Terry mentioned they are our trade partner, and we need to work this out in a way that preserves the sanctity of the system.
Well, as Terence mentioned, and then also the safeguards against China became a political issue, and in the cases brought by the President of the United States, I think there were 6 cases of safeguards, and 3 were dismissed by the International Trade Commission, and 3 went to presidential decision, and then President of the United States decided that it was not in the national interest to impose those safeguards. In the Brazilian case, we had several several petitions, which did not turn investigations. But we had those initial proceedings for safeguards in Brazil, and petitioners realized that if they kept the petitions as safeguards, very likely the political instances in Brazil would dismiss the cases also, and then they turned to anti-dumping investigations. Those investigations are now in process. We had change of circumstances review in relation to China's in Brazil. That was the glyphosate case. And I think that Terence mentioned another one here in the United States, a change of circumstances case in relation to China. In the United States, the review ended with a decision that China was not in that specific sector market economy. And in the glyphosate case review in Brazil, we under regulation number 59, as Claudia mentioned, we made a very thorough review investigation, and we came up with the decision that in that sector, in the glyphosate sector, China was not operating still in a market economy atmosphere. So that's it.
Yeah, just to add a little bit on the safeguards, on the Chinese transitory safeguards, Brazil has a provision, a decree 5556 from 2005. Not sure about that. But there is a decree regulating the application of transitory safeguards against China. We've seen some of these 11 anti-dumping investigations that are current going on. They were previously requested as a transitory safeguard, which hasn't turned out to be politically viable for the Brazilian government, and then it turned into an anti-dumping investigation. And I guess this is because the anti-dumping has a specific framework for on how it functions, and it's not that much political issues involved. And DCOM has been very used to conducting anti-dumping investigations much more than transitory safeguards against China. So, yeah, that's what I wanted to add.
So may we conclude that the remedies available, they are being used in a very limited way, in a very conservative way, always trying to avoid this political and the negative effect of with an important trade partner like China and others. And this would highlight, in my opinion, the necessity of including the rules in the Doha negotiation, because how we pathologists would treat a client that arrives at your office in such fever, I think is very important, the remark you have made. Any other questions from the floor?